The following is a local resident producers program. The program content is the sole responsibility of the producer and does not necessarily reflect the views or policies of CATV2, Oshkosh Community Access Television, the City of Oshkosh, the Oshkosh Cable Television Advisory Commission, or Time Warner Cable.
Hi again, everyone, and welcome to another edition of Eye on Oshkosh. I'm Cheryl Hentz, and Melanie Bleckel, my usual co-host, is out of town on business as we tape this show. I'm very pleased, however, to be joined by former Assistant District Attorney Tom Chalchoff. He's now in private practice here in the Fox Valley. And Tom is here this evening. Welcome. Thank you for being here.
Thank you very much, Cheryl. It's a pleasure and an honor.
We have invited Tom here because we are very honored also to have recently retired Judge Robert Haase with us, and we thought an attorney would be an appropriate kind of guest host. So welcome, Judge. Thank you.
A pleasure to be here.
It's a real privilege to have you here. We're taping this on January 22nd. You've been retired for just about a month now. What have you been doing with your time?
Oh, pretty much whatever I feel like.
Yeah.
I get a chance to do some of those things around the house that have needed doing for a long time. I get to do a lot of cooking, and I can do some cleaning, and I can do some laundry.
Wow.
But mostly it's been just putting things away. I brought home 7 boxes of stuff plus a bunch of pictures from the office, and now it's a matter of organizing all that, throwing some out, taking care of it, just putting things away.
Well, earlier today, and again, folks, we're taping this on the 22nd of January. Earlier today, you swore in your successor, Judge Scott Wolt.
Right.
Now he is officially a judge, so we can call him that. Right. You know, you served 22 years on the bench, and just, I think, did an exemplary job.
Oh, thank you very much.
A real credit to the county, and I think to judges everywhere. What, as Judge Wolt takes over your post, what kinds of things, what hurdles will he encounter right off the bat, and what kind of advice do you have for a new incoming judge like he is?
Well, as I was emceeing the investiture today, I did read him the 10 commandments for judges. And I haven't memorized them all, but they refer to things like patience and hard work and other qualities, being kind, don't take yourself too seriously, and ask for help among them. And I think one of the problems he will face is that his area of practice the last few years has been somewhat limited. And as a judge in Winnebago County, you do all sorts of cases.
Sure.
And so he's got some catching up to do with procedures and the law relating to some kinds of cases that he hasn't been handling, such as family cases, such as the probate type of cases, and there may be others. I sent in my resignation in March so that the governor would have time and could appoint someone very quickly. And I listed in that letter the reasons, because there are all these specialty seminars, Judicial College, the Sentencing and Criminal Law Seminar, specialty seminars in juvenile and civil and probate and all of these other areas of the law that he could have attended, or whoever was appointed could have attended,
Sure.
But the governor's office didn't see fit to do anything until it was too late to go to those, which really is not fair to Scott, because he has to now step in next Monday and do whatever kind of case comes down the pike. And it's just going to mean a lot of extra hard work and study for him to get up to speed with some of those procedures.
Now, they do have some kind of a judicial school or something, don't they? But it's
Oh, yeah.
just, how long, of course, is that?
Well, it's a 1 week. The Judicial College itself is 1 week long. I spent, 5 years, I think, teaching the jury trial problems course at that school. And every judge must go to the Judicial College once during every 6-year term. There's also a 4-day seminar, 4 or 5, in the spring, which relates to criminal law and sentencing, which everyone has to go to at least once every term. That one is particularly important now because of truth in sentencing, and some of the rules now that apply to sentencings of on felonies are quite complex, and they have the new sentencing guidelines that are somewhat complex and require a lot of work to get through and do them right. So missing that really is a problem. But the other specialty ones are there too. Some of them, he's familiar with. He's done a lot of workers' compensation and civil and some criminal stuff. But there's a lot of things that we have to do that people don't even realize we do.
So what can he, I'm sorry, Tom, just what kinds of things can he do then to kind of get up to speed? Or is it just going to be process of elimination of cases?
Well, it means you read a lot of statutes. There are bench books that have been developed by judges who volunteer their time to do that. And he can refer to them, which leads him back to cases and statutes that he can check on. But as I told him, if you got questions, call. And I know the other judges in the county will be happy to help with that too.
Okay.
When I went on the bench 22 years ago, the guy who hired me, Tom Williams, who was my partner, was my mentor. And if I had questions, I went to either he or to Judge Bill Crane, and they were always willing to help and to give you guidance and say, you might want to think about this, you might want to think about that, you might want to look at this or that, think of these cases. Since then, the bench books have been developed, which has been a big help also.
Good.
And that was kind of what my question was going to lead to. How confident were you in the assistance of other judges from the area, not only from Winnebago County, but the surrounding counties also? And I think you definitely answered that. I know as attorneys, we can talk to other attorneys for advice, but as a judge,
Sure.
a judge cannot any longer talk to attorneys,
Yeah.
other than, of course, judges. So you're quite confident that the judges out there, your experience, of
Right.
course, would really help them.
And Scott will be going through a mentoring program where he can sit with other judges and observe how they do things procedurally as well as the legal stuff. And everybody makes themselves available. I had the advantage, having run, it was a contested contest when Judge Arpin retired. And at that time, you were elected in April, and you didn't take office till January 1st. So I had those 8 months, and I quit about in July and became a house husband as I was winding down my practice. And I got to go to all of those seminars. And that just made a world of difference because I got on the bench the first day, and I was fully confident that I could handle anything that came before me.
Well, now, you brought up about the term and so forth, and that's one question that I had for you, judges. Your term, I believe, went until 2006, correct?
Yes. Well, 5 or 6, I don't know.
Okay, because I know some people have been saying he's got a one-year term to fill,
Yeah.
and yet in the book that I get from the county, it says 2006. So
Yeah,
when will he actually have to run again then?
He'll have to run in 2005.
Okay.
When a judge retires midterm, and it depends on whether their retirement is effective before or after November 14th or something like that. If it's before, then your election is the following spring.
Okay.
But mine was after that date, so it's a year from next spring. Or a year
Okay.
from 2004.
right.
So
And-
it'll be 2005, and if he has competition, if there is more than one running, there would be a primary in February of 2005, and then it would get down to, otherwise it would be the general election in April of 2005, and he would whoever is elected then would take office July 1st of 2005.
Okay. All right.
And along those lines, what exactly do you think of the appointment process, whereby a judge that is stepping down, retiring, as in your case, the judge's replacement is appointed by the governor? Do you have any thoughts on that? Do you see any better system using? And I know it was a question, of course, in the legal community, at least, that was important, and it is important, because you have a judge such as Judge Haase stepping off the bench, and it is important to replace him with qualified individuals, and I think, of course, the governor has.
Yeah, I think he has too. I had wished he had acted sooner.
Sure.
For the public's benefit as well as for Scott's. I think he had it down to 2 very good choices, and I could be happy with either one of those, and confident that either one of them would have succeeded in the job. But I wish he had done it sooner to give them a better shot at being prepared and ready.
Sure.
It's not easy to wind down a practice. I had 8 months to do it, and so it was very easy. But for Scott, on a very short rope, within a month to wind down a practice, that's not easy. And I think he's managed it, but some of that is because of his limited area, doing mostly workers' comp. I think that helped him to do that, leaving his partners in somewhat of a pinch, because that's dumping 1/3 of the total office load on 2 people that already have their own load.
Well, and possibly leaving his clientele in kind of limbo too, you know, if there's cases that are still outstanding.
Well,
So-
George Curtis and I were partners before I went on the bench, and I'm confident that, you know, those cases will be handled competently. There may have to be a little bit of shifting around.
Sure.
Excuse me.
No, I did actually see Judge Walt now in the hallways a couple days ago, and I asked him how everything was going. He said that he was very busy, long hours at the firm, catching up, closing out those cases.
Absolutely.
It's a lot of work.
Yep.
What are some of the hardest things about being a judge?
Well, sometimes you have a decision that you really have to think about. Obviously, you are making decisions that affect people's lives and fortunes, and you cannot take that responsibility lightly. The hardest thing sometimes is to reconcile what your heart says you should do and what your mind, because the law is such, says you should do. Those are some of the difficult ones, when you would like to be able to do something, but that's not what the law is. This is what the law says. And those are probably the most difficult things.
You do have some discretion, though. You have sentencing guidelines, right? But you've got discretion that you can exercise there.
Oh, sure. You have pretty much full discretion in the sentencing area, as long as you can justify and rationalize why you are doing it. You have to have a rational basis for what you're doing. But the guidelines are just that. You're not bound by those. And that's a very important thing, because to be a judge, by definition, I guess, says you're supposed to make judgments. And to have the legislature take some of that away sometimes gets in the way of doing that, and sometimes, frankly, gets in the way of doing justice.
What, you know, in 22 years, you've undoubtedly seen the law change a whole lot. What are some of the changes that really kind of stick out in your mind? And do you think they're good or bad?
Well, the law and our approach to it in this country has kind of been running in 20 to 30 year cycles. It gets very tough, and then it loosens up, and then it gets tough. I came in at a time when it was starting to get tough. And now it's starting to go the other way. For example, in the juvenile area, we started out with the idea that the courts would take the place of parents. And when I was a kid and I was in trouble as a juvenile, we went and sat with the judge for an hour each week for 4 weeks. That was what we did, and we talked to the judge, and he gave us things to read, and we discussed them. And in loco parentis, it's called, in the place of the parents. And then it got more and more formalized with some decisions that were made, and the rules became very, very strict and very legal, and with all these formal rights for juveniles and so forth. And finally, a big change in that area was the new juvenile code, where it was much more penal than it had been before. And 17-year-olds now were all in adult court, criminal court, if they committed crimes. So that was a big change. Whether that'll swing back or not, I don't know. Was it a good thing? I don't know how to answer that. You know, I've often said that between practice for 14 years and 22 years on the bench, I'm on the 4th generation with some of these families, and it's the same names every time you're on intake. And now the children of the children of the children are coming through this system. And so the pure penalty stuff hasn't worked. I've been talking to Senator Ressler about a bill she's proposing about more resources within the community for diversion rather than locking people up. Maybe you have to have some control over them more than we have now, but get them into treatment programs that are broader than just going through and doing Alcoholics Anonymous thing after an assessment, but actually getting them into programs where they can get more skills, say in basic math, in basic English, how to fill out an application for employment, what are the obligations of employment, as well as the treatment. But this bill would be based upon a substance abuse problem. And I think that by providing those kinds of services, we can change more lives faster, knowing that these things are addictive and you can't just stop them, you can't turn them on and off, but to provide the resources to give them the help to fall back on, to hopefully prevent relapses and keep them productive citizens.
Okay.
Should be less costly than imprisoning them. We can provide those services in prison, but it's kind of a false, I mean, it's not a real life situation.
Sure.
But the pain you see because of substances, I've often said my estimate is 80% to 90% of my criminal and juvenile caseload would be gone if we eliminated alcohol and illegal substances.
Wow.
That
sends a heck of a strong message.
It's that bad.
Yeah. Tom, go ahead.
I'd love to continue that. I do want to change a little bit. I'd like to know, especially practicing in the legal profession, what criticisms do you have of the attorneys that are before you, that have practiced before you, particularly in the last decade?
I don't have a lot of criticisms. Mainly they relate to taking positions that I don't think are particularly helpful to their clients at times. I'm a great advocate of mediation. I think it's a much better way of resolving disputes than litigation. But on the other hand, it's a necessary thing. And what I see are some younger attorneys sometimes will come in a civil suit, and they're trying a suit because they have to have so many jury trials to qualify for some sort of certification as a trial specialist. And sometimes these things don't help their clients. Sometimes attorneys don't like each other, and it's costing their clients more than it should to get a case settled because these attorneys don't like each other. They just take absurd positions. Sometimes they let the clients make decisions, for example, what a case is worth, instead of listening to their attorney. I mean, there are a lot of reasons why some cases go. Sometimes the attorneys have an unrealistic evaluation of a case. Sometimes attorneys don't evaluate it soon enough. I'm talking about the civil area.
Sure.
But it also applies somewhat to the criminal. They don't evaluate their case early enough until they got so much money invested in it they can't afford to settle. Then they have to try it and take a chance just to recover costs. So that's mostly the criticisms I have. We're blessed, particularly in Winnebago County, with a fine bunch of lawyers and much less litigious than, say, Outagamie County. Our court commissioner, Joe Yana, has been saying for years that something like 80% of the contested divorce cases in Winnebago County involve a lawyer from Outagamie County. And that's just a legal culture up there that is more go to court and fight than in the Winnebago bar, where they say, let's get this done. We're helping our clients by saving them money, getting this done on a realistic basis that they're happy with. In fact, I had, I'll never forget it, it was years ago, 20 years or so ago, when a lawyer in a family case from Outagamie County came down. The case was set for a day-long trial.
Sorry to interrupt, your mic just came off there.
Mic. And so we got him talking, and he finally came in and he said, good news, we've got it settled. I said, good, let's go in 15 minutes. We'll put the thing on the record, get the divorce done. He says, oh no, about an hour. I said, why an hour? He said, well, you got to put on a show for the client. Now, that kind of an attitude really irritated me.
Well, what do you think accounts for such a different mindset just from one county to a neighboring county?
I think it's just the legal culture that's developed over the years.
Strange. Did you have another question, Tom?
I did, actually. Judge Haase had mentioned mediation, and I've always been very interested in mediation. I agree with you completely that mediation should be used more as a tool. It's more beneficial to the parties. Would you comment on where you envision mediation's role in the future? It certainly has been gaining steam throughout the legal justice system, and I know that you are a big proponent. You've initiated the Winnebago Resolution Center, and could you comment on that, and for the viewers, kind of let them know, inform them?
On what mediation is?
Mediation and the process that Winnebago County uses.
Well, the process of mediation is getting the people who are contesting something together in a room with a mediator or mediators who are neutrals, who aren't there to tell you what they think the case is worth. They're not there to tell you what the law is. They're there to facilitate a discussion between the parties that will lead to a resolution. In this process, these people get the chance to tell their story. Now, that may not happen in a courtroom if you go to a trial because of the rules of evidence. They just can't tell their whole story.
Right.
It's restricted. So that's one thing they can do. It gives them a chance to explore each other's feelings, to see what effects has this had on the other person. It allows them directly with the other person to talk about how has this affected me, and leads to this resolution through that with the guidance of the mediator. And this also involves a process of meeting separately with one side or another from one time to another to talk about things and see what do you think about this, what might you propose, is there any room you have here? And you do the same thing with the other. Sometimes it involves shuttling from one to the other, but I really prefer to talk to this one, give them a job, talk about these things, make some decisions, and be ready to make some kind of an offer. And then talk to the other ones and tell them the same thing. Now, in doing this, you can also make some suggestions. Is there room to try it maybe this way? Is maybe this is okay, but you haven't got the money? Can we work out a payment plan? You can't do that in a trial. I mean, it's this amount or that amount, and you owe it, and there's a judgment. But here you can say in mediation, okay, we'll agree on this amount, and I'll give you time to pay. And then the backup thing is if you miss a payment, then I get my judgment for this amount. Lots of cases are settled that way. And people go home, they've saved money, they've saved the emotional stress of a trial, and they've saved the physical stress of a trial. Because a jury trial is not an easy thing for a litigant to go through. First of all, they're in a strange element. They're relying on lawyers, that's fine, the lawyers know what they're doing most of the time.
We hope.
Most of the time. But it's very stressful, and it takes a lot of time, and it's extremely expensive. And the lawyers now, since the Supreme Court passed our alternative dispute resolution rule, 15 years ago now or so maybe, the legal culture has changed so that lawyers are now realizing that they can get a case, like a personal injury case, an auto accident or something, get some basic discovery done on how the accident happened and who says what, get some doctor's reports in writing, and they can take this to mediation and save tens of thousands of dollars for expert witnesses and bringing all these people in and getting the case done. And it's interesting how, lawyers have their opinion, this case is worth so much. I think liability is 85%, and I think this is a $150,000 case. The litigants don't always think that way. I had, to talk shop here, I had one case that I mediated, and the demand was something like $120,000, and the offer was something like $8,000.
Oh.
Now, we finally settled this after about 2-3 hours of mediation, that the agreement was to pay, and it was, I don't remember the exact figure, but it was something like $24,279.82. And they agreed on this. Said
Wow.
the check will be in the mail. And the one side left, the insurance company people left, and I just kind of looked at the lawyer for this family, and it was their daughter had been in an accident, and the parents were there, and she was a teenager, so she was there also. And the lawyer said, "You want to know, don't you?" And I said, "Yeah." And he said that was enough to pay the cost of this action, to pay my fees, to pay all of her medical expenses, and pay for her orthodontia treatment. Now that had nothing to do with the case. But that's when you get to people's real interests, is what settles cases through mediation.
So they wanted to be made, the litigants, the plaintiffs in this case, wanted to be made whole, and that was it.
And they wanted a little extra for this.
Yeah.
And that's the kind of thing that happens. But the parties get to tell their story. If there's an agreement, they're much more likely to pay and be paid than if you get a judgment. So, it's just a better system all around.
And you see its use increasing.
Yes. Yeah, and it's not the only one that's out there. Arbitration has been around. There are, I think, 9 different alternative dispute resolution systems that are authorized under the statutes. There's binding arbitration and non-binding arbitration. So the one, obviously, if the arbitrator or the board of arbitrators says it, that's the end of it. The non-binding, it's used as, okay, this is what the arbitrator says, and we use this as a stepping stone to more negotiations. There is direct negotiations itself, which lawyers have always been doing. There's also a summary jury trial, and I've done several of those, where instead of spending a week and a half on a jury trial, we go in and have the lawyers each make essentially a 1-hour argument to a panel of 6 off the regular jury panel. They make their arguments. Everything they say has to be backed up in discovery somehow, and then the jury makes a decision. And when they come back, they're surprised to find that we're all sitting around a table. All the jurors, the lawyers, the parties, everybody, and I start the discussion. We all talk about what they found and why, and that leads to settlements. And the lawyers can ask them questions and talk to them, and the parties can exchange views, but you don't get that kind of exchange of stuff in a jury trial.
Right. You had earlier, Judge, mentioned about truth in sentencing, and that's something that, certainly we've all heard an awful lot about.
Mm-hmm.
I'm not sure that a lot of the viewers truly understand what truth in sentencing is. Could you maybe just, for the viewers' benefit, just give us kind of a brief description of what truth in sentencing is, and with that, if you think it's been successful, or if it has some kinks in the armor there?
Well, success is hard to measure. If you want to talk about getting people off the street longer, it's been extremely successful. If you want to talk about what the added cost has been, it's been very unsuccessful in terms of cost. Cut to its simplest terms, it means that if a judge sentenced somebody to 5 years in prison, they're going to serve 5 years in prison. Before truth in sentencing, and this only applies to felony cases, if I sentenced to someone to, say, 10 years in prison, after 2.5 years they would be eligible for parole, and the decision whether or not to release them would be in the parole board's hands. Now, if I sentence someone to prison, and let's say I have a 10-year range, I have to make part of that a time in prison and a part of it a time on what's called extended supervision. So I can still do a 10-year sentence, but I might say 4 years in prison and 6 years on extended supervision. Now, if they get in trouble in prison or if they get revoked, they could wind up serving the full 10 years in prison, but there's no more parole.
Okay. And the extended supervision, what exactly is, they're basically allowed to come home then?
Well, it's like a probation.
Okay.
It would be what you would call being released on parole before, where you would be supervised by a trained worker from the probation and parole department. It just eliminates parole and makes it like a probation. And there are conditions that are set by the judge at the time of sentencing, that once you're released from prison and on extended supervision, here are all the conditions you must meet. Pay your restitution, pay the costs and fees, all of these other things, follow the rules.
And then if you don't do that, you can be bounced back to
You could be
prison
sent
to
back
have
to
to
prison.
finish the rest of your term.
Absolutely, yeah.
Okay, the rest of your sentence. Okay.
So it really just means if I send you to prison for so much time, you're going to serve that much time in prison, and there is no parole. Once you are, and that time can be extended if you misbehave in prison.
Okay.
So that time to release could be. But once you're released, you're on extended supervision to the end of your sentence, and if you violate, you can be revoked and wind up spending the whole time.
Okay. So as far as getting the criminal element off the streets and keeping them off longer, it's successful. But
I would say so.
cost-wise,
Well,
bad
it's
thing.
very expensive to
Yeah.
do, and some of the people in there could do probably pretty well on the outside, and do when they're released.
Okay. I want to talk about the district attorney's office for just a moment. The district attorney, there was an article in the paper earlier this month that the DA's caseload is the smallest in 9 years. And DA Bill Lennon was quoted in the paper as, saying that it could be because different prosecutors have different thresholds of evidence, and that they may require more from law enforcement than other prosecutors do. He also said that it could be that there was less criminal behavior now than there was under former DA Joe Paulus. Do you have any thoughts on the smaller caseload, or do you think that there's no one single thing that a smaller caseload could be attributed to?
I think both of those are valid reasons why it could be. There is a third that he didn't mention, and maybe he's more politic than I, but I think that there was a time when we were seeing some overcharging in the DA's office, a conscious effort to build caseload statistics so they could get more people in the office. Now this is accomplished. Let's say you have 5 burglaries. Now you have a choice. You can file one complaint with 5 counts, or you can file 5 different cases. And I think there was some of that 5 different cases stuff going on at one point.
Okay.
I think that has stopped now that Bill is there. I think it was part of the regime change there. But I think those are the 3 basic reasons.
Okay.
I can't say that I've seen any less crime.
Well, no, when I read that in the paper, I thought, I don't know where the less crime would be coming from.
I think it was more
because-
charging practices than anything else.
Okay.
And part of that is one of the reasons Bill gave, that maybe you don't just file everything that the police bring in. You say, I wonder about this, check this out a little further.
Sure.
And that could very well be part of it
Okay.
too.
Can I just ask one more question, and then I'm going to
Absolutely.
toss it back to you, but
Absolutely.
I kind of want to stay on the DA's office thing for a moment. We know, obviously, that the FBI is investigating, things that happened under former DA Joe Paulus, and no one can really deny the fact that they're involved. I know that was a denial for a while, but that doesn't wash anymore. I also know that you have, been a party to this as far as giving some opinions, testimony, what have you. But I'm not going to ask you to comment on that because I know that you can't. But some of the comments out in the community from the public at large are just that, well, gosh, if nothing has happened yet, there must not be anything to these allegations. And then there are others of us, myself included obviously, who believe that just because nothing has come yet doesn't mean that there's nothing there to be found. There may very well be. Could you at least, Judge, speak to the length of time that it has taken so far, and is this normal for an FBI type investigation to take this long?
Well, first of all, I've never been involved in an FBI investigation before, so I really don't
I'm
know
sorry,
how
I thought
long
that they
it
had
takes.
talked to you, though.
Well, but I don't have no information about length of time or
Oh, I see.
averages.
Okay.
That's what I don't know about. As far as I know, there is an ongoing investigation. I gleaned from the latest thing I saw in the paper by its referral to Washington, D.C., that they must feel there's some kind of prosecuted merit, because I don't know why they would do that on the basis of the federal prosecutor in Milwaukee being related to Vince Muskubik, a brother, I think. Why would they consider that a problem if they didn't think there was anything there to prosecute? So based on that, that's an assumption
That's
that
an
I'm
interesting
making.
point.
But from my perspective, I don't know if anything was untoward. A judge has an obligation under the Code of Judicial Ethics to report misbehavior by lawyers, or other judges for that matter. So once these allegations started coming out publicly, there was really no choice that Judge Key and I had but to refer this both to the lawyers control group, as well as when it appears that people were alleging crimes had been committed, to some investigative unit. And the FBI seemed to be willing to undertake it.
Okay. Go ahead, Tom.
We were talking about Bill Lennon and the job, and it was quite a large task that he had to come in after Joe Paulus, especially after Paulus had been in office for such a long time, and I'm sure it was quite an adjustment to him. How do you feel he is handling in his office and all the prosecutors under him? Are they being effective? Are they doing a good job?
Oh, I think so. As far as I can tell, they are. There was a big exchange of people between Outagamie County and Winnebago. And sure, I think they're doing a good job. I think they're looking at things realistically. And frankly, you can talk about plea bargaining, but without that, the system would collapse because they just don't have enough prosecutors, there's not enough investigators, there are not enough people to keep the wheels turning without plea agreements. So the prosecution needs that, but really the defense does too, because often they don't want to, or their clients don't want to take the risk of what they might be facing if they can get a good recommendation from the DA or a reduced sentence or some other consideration, such as our volunteers in probation program or some of these other things. Even for the younger offenders, the expunction, whatever that means, the legislature's never defined it. On State Records Management Committee, we tried to get the legislature to tell us, what do you mean? What do you intend by this expunction? No, they would never do it, so we did it administratively because we had to advise our clerks of court, and so we just told them, this is what it means. You take the name off the file, and you don't let anybody see it, and that was it. But we had no control over things outside the judicial system. So that meant that we had no control. We couldn't tell the cops, you got to erase your records of this arrest. We couldn't tell the crime bureau that you got to get rid of this off of your computers. We just didn't have that authority to do it.
Go ahead, Tom.
Now, I think that a lot of people, the public, are not aware of guidelines, certain guidelines. And I thought maybe you'd like to comment on the process, how the judges come up with the guidelines, because it is in fact the judges in certain areas that come up with the guidelines. I know that you were a chief judge for 6 years and deputy for 3 years. Could you comment on that system, the process of coming up with the guidelines specifically for drunk driving, the OWI offenses? And again, the reason I'm asking is because quite often the public, you hear comments from people that that person had a 4th offense and they only received a certain amount of jail time. And then I think the public needs to understand how these guidelines come about and what the thinking is behind them.
The initial legislation that created the guidelines for operating under the influence ordered that each judicial district in the state come up with guidelines for their district. And my predecessors as chief judge at the time, I think it was Judge Nelson from Calumet County, appointed the committee, and they came up with guidelines. And each chief judge after that had to update them as changes in the law came through. So it's been done by committees of judges in the with district attorney involvement that have come up with the guidelines as they've needed to change from time to time. But again, you have to remember, guidelines are that. And you're not bound by them. You can go more severe than those guidelines if there are reasons to do it, and you can go less if there are mitigating circumstances involved. And part of the problem is every time you have a district doing this, you have a boundary line. So there's a boundary line between Winnebago, which is in District 4, and Outagamie, which is in District 7. They have different guidelines. And several years ago, there was an article in the paper about how the people in Milwaukee are sentenced much more severely under their guidelines than Winnebago was. Now that sounds nice, but the people in Milwaukee didn't spend any time in jail even though they were sentenced to 60 days because they were on a bracelet program. In Winnebago, they may have gotten only 20 days, but they sat there 20 days. So there are differences of that kind too. But again, we get back to judge exercising discretion. That's their job. And every individual is different. And every circumstance is different. And we cannot simply say everybody who is convicted of this offense gets the same sentence, because it's entirely different. I used to do for kids, I would do sentencing exercises, and I would go in and give them sets of facts. Here's 2 people, they're both convicted of this crime. Here's what the maximum punishment is. You can sentence them to anything, including probation, up to this. And then I would give them things like one is Pat and the other one is Frankie, and we'd go through all of these circumstances, their ages, and then I would say, what else do you want to know? And then we would get into these questions. Well, then they find out that Pat is the male and Frankie is a female, and it went on down like this. One of them's 38 years old, the other one is 19, and all of a sudden, they say, well, gee whiz, that would make a difference. But that's the kind of thing you're dealing with, and that's what exercise of discretion is. It's looking at all the facts that you got in front of you and making a judgment.
In your 22 years on the bench, and of course I lived here for the majority of that time. There was a short time that I was away while you were on the bench. But I really, and as a reporter, I have covered a tremendous amount of court cases, and your court certainly has been one of them. And I've observed a lot of judges, and I think why you were such a successful judge is you weren't too harsh, you weren't too lenient. You were middle of the road, and you weighed each individual case on its own merits and sentenced accordingly. And I think that that is probably a model that all judges should follow. And I think you just, as I said earlier, you did a marvelous job. During your 22 years, how many times, if any, did anyone ever run against you?
Just the first time. What was it, at my retirement dinner? Judge Kirk from Wapaka County, we were elected the same year. And he actually lost his election by 3 votes or something, then on recount he won it by 9. I won mine in a contested race against Attorney Ron Lampe by 190. So Phil Kirk was telling how we met at Judicial College, and he said it was Squeaker Kirk and Landslide Haase who hit it off, so we've been friends ever since. But thank you for the compliments. Other than that, no one has run against me. But that's pretty typical of sitting judges. It's fairly rare, and there's usually somebody who has some pretty strong reasons why they would run against a sitting judge.
Well, obviously, we have one of those coming up very soon. In Circuit Court Branch 5, longtime sitting Judge Bill Carver being challenged by a current Deputy DA, John Jorgensen. And yes, now, Jorgensen, many viewers will recall, in the 2002 District Attorney race, had thrown his hat into the ring, was going to run for District Attorney, and then when Joe Paulus decided he was going to run for the position again, Jorgensen pulled out. Do you care to make any predictions on what may happen in this race? How tough is it going to be to beat an incumbent?
Well, it's always difficult because they've got a support group that's been there for a long time.
And a campaign war chest, probably, of some.
I don't know.
Some dollars,
I really
think.
don't know. Judge Carver, as you say, has been there a long time, far longer than I have. Even though we're about the same age, we've discussed, he says he's just not ready to retire yet. I respect that. I'm ready to retire. And part of the reason is I can. And I thought there are other things I would like to do, and while I'm in good health yet and able to do it, why not? Why continue with it? But no, I don't know how that's going to come out.
Well, it's going to be interesting, and once we get through the primary election for the school board and the presidential preference, we will be getting those district attorney or those judge candidates on the program too. We've seen more and more law and court-related programs turning up on television over the last I would say probably 10 or 15 years. LA Law was probably one of the earliest premier ones,
Sure.
And they just did such an outstanding job on that show, I thought. And they've all sort of been born from that show. Mm-hmm. What is your impression of some of these shows, and do you think that they give a fair representation of what truly goes on in our court systems?
Not very often. They have had an effect, though. The LA Laws and some of these others where you're actually, what's the other one? The Crime and
Punishment?
No, the one where they got the cops arresting somebody, and then I forget what the name of it is. Anyway, you get a fairly accurate representation.
Law and Order, my
Law and
crew
Order,
member
that's
just
the
told
one.
me.
Yeah. The first effect I noticed from these was that in jury trials, jurors turn off after about 2 minutes, and they see these concise arguments on TV, and they think that's what it is. And when I started, lawyers would drone on. I remember one of the first trials I had was with Alan Eisenberg out of Milwaukee, and I think his closing argument in that case went 4 or 5 hours. When I played Clarence Darrow in a play at the Grand a few years back.
That I saw you in.
Yeah, and it was when he did his closing argument, and that was in municipal court here in Oshkosh in 1898. He argued for 2 days, and the playwright sucked out the pith and built a play around it. But even then, with the Grand, I had 45 minutes. But the jurors got used to hearing these things real short and concise and right to the point, and so they would turn off. But there's still what I'm seeing with the lawyers is they don't really understand closing argument is for persuasion. And they don't persuade. They just review facts and said, I'm sure you'll find this or that, instead of persuading. You see a good jury trial lawyer really working, and you'll see him persuading. That I don't see. Now, the other thing, you see these things like Judge Brown and People's Court and all this. If I acted like that, I would have lost my ticket long ago. I mean, it's just, this is totally unethical. You can't do that. You wouldn't do it. And what the public doesn't always realize is that these are not, they may be started out as real cases, but all of a sudden, these are paid people who are going in and doing this and acting bad. I mean, it's like Springer. And the problem with that is people come now into court by themselves, say in small claims cases, and they think that that's how you should behave. And I have to threaten some, you know, one more remark unless I ask you a question and you're going to jail for contempt, understand? I don't know. but they'll stand up and interrupt and all kinds of things. I think they should scream at each other because that's what they see on TV. Right. But those are not real cases. By the time you see what you see on TV, they're paid actors.
Well, sure, they're all being paid for their appearance.
And they can't lose. They're all going to win.
Yeah. Well, and as you said, even the judges, I think one of the worst, and she started out probably being okay, is Judge Judy. She has just become so rude to these people. I mean, I've never seen anything like it.
She speaks a lot of common sense, but you can't act like that. Manner, from research, we know that most litigants are more concerned that they were treated fairly than with the outcome of the case. They want to know that they had the chance to present their stuff and that you listened to them and that you were polite and respectful. That's more important than winning.
Okay. All right. We are winding down to probably about 13 minutes yet. Did you have a question on courthouse security or something else
Yes,
you
I
wanted
did.
to ask?
I'll make it very brief. Courthouse
That's what our
security.
courthouse security is, very brief.
Courthouse security to the tune of $635,000. I believe that's what they're looking at, somewhere around there. In your opinion, is it needed?
I thought it was, because the number one thing you want to do is keep the metal out, keep the guns out. The incidents we've had in this state have involved guns. And we've had several incidents in Waukesha County years ago. There was someone shot and hostages taken. A year ago or so in Milwaukee, or 2 years, there was an incident. And these are the kinds of things you do. And the first rule, the federal marshals have been here 2 or 3 times, and that's almost an impossible building to totally secure. But you could do number one, and that's to keep out the metal. I think it's short-sighted not to think sooner or later something will happen. There's not a federal courthouse in the land that you can get into without going through a metal detector. We're living in a pipe dream world if we think that sooner or later there won't be something happening. And we've had incidents here. We've had some people get out of hand in the family court area and had to be taken to the ground. We've had criminal people who get obstructive and interruptive and sometimes violent during proceedings, and we have cops there to help with that. And we know that we had problems because when we used to have, we have a movable detector, and we'd set it up by the courtroom door sometimes. And people would get off the elevator on the 4th floor, come up, see that detector, turn around, go back down, and come back 10 minutes later. And you know, they put something in the car so they could. So we know that people are packing stuff.
Sure. Yeah. Well, I know when courthouse security first started being talked about, as Tom mentioned, the price tag was $635,000.
Well, that was one plan.
Yeah, that had gotten shot down a couple times by the county board. And then we had Tom Peck on the show late in 2003, and of course he's a county board supervisor, one of several. And he was telling us that there are a series of proposals now that are in the multi-million-dollar range, and they're spread out over something like 10 or 12 years. And I have not yet seen what's all involved in that. Do you know what they're looking at doing? And
I have not followed that since Judge Gritton came on board, and he was very interested in that issue. So he's taken over that security committee, which used to be chaired by Judge Schmidt. And he's been following through and doing the things with it. But you know, we have to realize that we're dealing with a 1938 building. It's so old, it's my age. And it has tons of entrances, and at one time it housed the entire Winnebago County government. For example, the chambers that I have now once housed the entire welfare department for Winnebago County. So it was designed for 2 courtrooms. 3, I'll take that back. 1 circuit courtroom and 2 county courtrooms. And then as they added another county judge, they had to find space for that. As they added a 2nd circuit judge, they had to find space for that. And now those 3 county judges then became circuit judges in 1978, and now we've added a branch 6. And for at least 10 years, our statistics have shown on a weighted caseload basis that we needed over 8 judges. Now we've gotten some help because we added another court commissioner, so we have 2 court commissioners plus the family court commissioner. That takes off some of the load. The mediation system is taking a bunch out of that, out of the trial calendars at least. So we were getting some help from that, but that's an antiquated building. The study that was done has shown that the courts of Winnebago County will not all fit in that building, even if you get rid of everything else. And so you're faced with adding to it or trying to rebuild it, which is more costly than if you just had built a new one
Sure.
out by the jail. And the numbers on that didn't even take into account the savings on personnel. For example, now you have 6 courts, so you have 6 people answering phones. If you have it structured right and built right, you've got maybe 2 people answering phones and directing this stuff. That kind of savings wasn't even taken into account. I'm just looking at construction to make that do as opposed to just building new.
Well, and you've not only got to secure, if you're going to secure the courthouse, you not only have to secure the courthouse, but then you have to secure Judge Bruce Schmidt, who's over in the safety building,
Yeah.
and which is our other branch over there. So I don't know how you begin to do all that, and with us in the budget crunch that we're in, I don't know what the answer is, but maybe they should at least look at putting that magnetometer or metal detector back.
Well, that was the original plan. It was locking down the doors with alarms on them, so they had to come in one entrance, and at least getting rid of the metal.
Yeah.
And
Although I think they maybe went a little too far with like the toenail or the fingernail clippers.
Well, they do the same thing on an
yeah.
airplane.
Yeah.
For why, I don't know, but
Yeah. As we're quickly running out of time, acting and singing are obviously major hobbies of yours. You're very good at it. I've
Thank you.
seen you in at least 1 or 2 productions. What are your plans as far as acting and singing goes? You're going
Well,
to
I'm-
continue with that, I'm
Sure,
assuming.
I'm still in my barbershop quartet and active with our barbershop chapter. So we'll be doing a bit of that. We'll be on the Oshkosh show with our quartet coming up March 27th, I think it is. And that involves more than just singing. I mean, I write scripts and I coach other quartets. I direct the chorus, arrange music. I've composed a bunch of music for barbershop. So
Really?
It's a lot of stuff. Yeah, a lot of stuff.
What kinds of, you have any particular theme in the songs that you've composed?
Well, I've
or-
been in a quartet called Ham and Rye, and that's W-R-Y, since 1974, and I've written several of the numbers. Hello, We're Ham and Rye, which was an opener, and we had a closer at one time that we were really operating on a pig theme there for a while. Love a pig today. So there's been a number of numbers from that, but a bunch of stuff that has been I've worked on.
Where did your interest in performing and writing and arranging, where did all that come from?
I think it just came from when I was a kid. My oldest sister would sit down and play the piano, and my other 3 sisters and I, and everybody would just join in and harmonize, and it just kind of grew from that. I found the Society for the Preservation and Encouragement of Barbershop Quartet Singing in America, and I liked it. There's something about, especially if a quartet, just 4 guys, each one hanging on to your part and ringing chords. You get a synergy that produces overtones, and it's just a wonderful feeling. The hardest day in my life, in anything, judging or anything else, I go sing for a half an hour. I'm not angry anymore. I'm not stressed anymore. I'm totally relaxed and smiling.
How long have you been in the barbershop quartet?
Well, in the society since 1959 officially. So it's been a while.
You may have known my grandfather because he was in the barbershop quartet, Joe Hentz.
I've heard the name, yeah.
Yeah,
Sure.
and even he loved it so much, Judge, that even after he had to have his voice box removed, and even after that, he was still up there, couldn't utter a sound, but he was up there, proud as could be, singing away.
Yeah, I didn't get to Oshkosh to '68, so it may have been before my time, but I remember the name.
Yeah, yeah. Do you have anything real quick?
Well, I would like to know what your future plans are regarding mediation. I understand you had a mediation this morning. Are you going to continue?
Well, I'm still working as a volunteer mediator with the center, so I go in Thursday mornings and do that on whatever cases come down the pike. That's volunteer work. And I've also been recruited by an outfit called Resolute Systems, incorporated out of Milwaukee. They're statewide and nationwide. And so if they get jobs, I can go mediate those. So I'll handle whatever comes down the pike.
Excellent.
Any plans to practice law at all, even on a very limited basis?
No.
Just do mediation?
No, the mediation is fun. I don't want to get into practice with all the malpractice problems now. Well, let's face it, I've kept up on some of the law, but it's very different from being in practice with what you have to know as a judge. It's a different approach to it. And no, I really don't want to get into practice.
What do you think has, or what do you feel has been your greatest accomplishment in your 22 years on the bench? I know that's a long time to try and pick out, a couple of things, but
Greatest accomplishment.
What are you most proud of?
There are some cases that warm the heart. When I get a letter from someone that says, "Thanks for sending me to prison. I needed that." When I see an article in the paper out of the blue one Sunday morning, it says, "Judge Haase's the nicest man in the world. He sent me to Lincoln Hills, turned my life around." You get some of these stories. I got some letters, I got a letter when I was going to retire, and it had a couple pictures of a baby being held. I'm holding the baby. You did this adoption way back in 19-something, and here's the boy today. He's a high school athlete, and it was so nice and so wonderful, and you ought to know. These are the kinds of things that you can't, there's no price tag on them.
Sure. One very final question, and we'll add levity to this. I've always wondered, what do judges wear under their robes?
Well, I can't give away the secret. You'll have to go exploring on your
Oh,
own.
no, I can't. It'd probably be found in contempt of court.
Maybe depends on what court you're in, I guess.
Well, Judge, thank you very much for being here. It
been a
has
real
been
pleasure.
a real pleasure, and thank you again for just all of your years of service.
Well, thank you. I appreciate that. And thanks for asking me to be here.
And best of luck with retirement, and keep up the good work with mediation and your singing and acting. Thank you very, very much.
Thanks for having me.
Tom, thank you
good to
very
see
much
you.
for
Thank you,
being here
Judge.
too, and pinch hitting for Melanie tonight. And as always, thank you to you folks for joining us. And check out our website, www.eyeonoshkosh.com. We'll see you next time. Until then, keep your eye on us. We've got our eye on Oshkosh. Take care.